Great, welcome everyone. We'll give participants a minute to join. Thank you for joining us today. All right, so we're going to get started as others join. Thank you for joining us today. This webinar is From Filing to Finalization, Steps to Take and Pitfalls to Avoid in Filing an Adoption and Family Court in New York. My name is Jeannie Ortiz, and I am a Senior Program Manager at Pro Bono Net. Joining us as well today is my colleague Yvonne, who is behind the Zoom webinar controls and can assist with any technical issues. So Pro Bono Net is proud to be a co-host of today's program. For those not familiar with Pro Bono Net, we are a national nonprofit organization based in New York City, and we leverage technology to expand legal help and access to justice, and also facilitate resource sharing and trainings to legal aid and pro bono attorneys. I've had the pleasure of working with Karla Johnson at Mobilization for Justice to organize a series of webinars on kinship law this year. And this is the second one that we're bringing to you today. We want to make this an engaging session, so please use the chat to share your practical tips or resources with other attendees if you'd like to do that based on what presenters are sharing. And please use the Q&A function to ask questions. We will go through questions submitted via the Q&A at the end of the webinar. But if there are quick questions that our speakers can address during one of the sections, we will do that as well. We just ask that when you ask your question, we request that you please refer to the topic so that we know what your question is about. That'll make it easier for our speakers. All the materials of today's training will be uploaded to the chat as well. So you should be seeing those on your end, and you can download them at your convenience. And in addition, attendees that would like to view a live transcription of the webinar can do so by enabling this setting that you see on your screen under the Show Captions icon. The materials and the recording will be posted to the link you see on your screen, and we can share that via the chat as well. If you're listening to us via your phone, the link is probono.net/ny/NYC/kinship law 2023. Pro Bono Net NYC is part of Pro Bono Net New York, which is an online community of law students, legal aid attorneys, and pro bono attorneys across the state. And you can find here a list of introductory resources for those interested in pro bono, a calendar event with other trainings of interest, and there's no cost to join. So if you're not already a member, we encourage you to sign up. And with that said, I'll hand it over to Karla, who has organized a great group of experts on today's topic. Karla?
Hi there. Good afternoon, everyone. I see that folks are still joining, but we do have an amazing panel today and amazing presenters alongside myself. So I just want to go ahead and acknowledge our two speakers, Maria, and just briefly to give you a bit of Maria's experience and background. Maria is an assistant deputy counsel at the New York State Judicial Institute under the leadership of the Honorable Faith E. Davison, Dean. Maria began her position in the Unified Court System in 2002 as court attorney to now retired family court supervising Judge Joan Coney. Maria presided over permanency hearings for approximately 10 years in Westchester County Family Court. And in addition to her duties as referee, she's worked in administrative offices and supervised adoptions filed within Westchester County Family Court. And she's done that for approximately the past 19 years. Maria also has organized the annual Adoption Day celebrations and other important other important 9th Judicial District Awareness Heritage Month events during that time. And at the height of the COVID-19 pandemic, Maria helped to launch the 9th JD's faith-based court access program and continues to assist with its expansion throughout New York State under the leadership of the Office of Justice Initiatives. The remainder of Maria's bio is in the material. So again, thank you so much for joining us and being with us to present today, Maria. We're so happy to have you. In addition to Maria, Kelsey joins us, and just a bit of brief background and experience for Kelsey. She's been a court attorney for Bronx-based Judge Gordon Galkas for the last 4 years, where she's handled primarily child protective and delinquency matters. Before her tenure in serving as a court attorney, she worked in Queens Family Court Legal Services, which is a legal arm for New York City's ACS. She's a graduate of New York Law School and McDaniel College in Westminster, Maryland, with a bachelor's degree in history and psychology. We share a bit of similarities. I mean, I was also a psych major. Just very briefly for myself, I'm a senior staff attorney with the Kinship Caregiver Law Project, which is essentially the family law-based project with Mobilization for Justice. For folks who know, it was previously MFY. And in this capacity, I represent low-income kinship caregivers seeking legal custody, guardianship, and adoption assistance. I also help in other areas for foster care, as well as SIJ matters. We are a small but mighty project and have been advocating in the space of adoptions for some time. I will spare the remainder details, and hopefully we can go ahead and jump in. Again, if there are any questions, please do drop them in the Q&A feature. And I will turn things over to Maria now.
Thank you, Karla, and thank you to Mobilization for Justice and Pro Bono Net for inviting me to speak today on this esteemed panel. And I did not realize that Kelsey is also a New York Law School alum, so I'm happy to join a fellow alum in this endeavor today. I'm very excited to speak to all of you about adoption. It has been part of my heart and family court for over 20 years. I get to continue a bit of that being here at the New York State Judicial Institute. However, I had the full pleasure of supervising them and continuing to answer questions about them and speak about it to date. So let's get right into what is an adoption. And before I get into that, actually, I would like to begin by saying that the adoptions have changed since I first started working here, and actually over the past 30 years. Not only have we seen that adoptions have moved from closed to open adoptions, but we have seen an overall decrease in the number of adoptions that are filed throughout the state and even nationally. And you can find some of those statistics of those exact numbers dating back from 2019 to the present. You can Google them online and you'll find many articles on those numbers, but I'll give you an idea. Of course, taking into consideration the effect that the COVID-19 pandemic had throughout our nation and within our courts, and also with regard to filing of adoption. So to give you an idea, in New York, private adoptions made up about 59% of domestic adoptions. That number declined by 43% in 2020, and they continue to do so. So that's a pretty big drop. And we'll have to just wait and see how those numbers continue to show in the upcoming year. So getting into what is an adoption, Domestic Relations Law Section 110 defines adoption as a legal proceeding whereby a person takes another into the relationship of child and therefore acquires and incurs all of the responsibilities and benefits in respect to that child. Next slide, please. Okay. So going into that a little bit further, in an adoption, the birth parent's rights are terminated typically, and the court will then confer permanent legal responsibilities for that child to the adoptive parents. Well, for example, in a step-parent adoption, there may be an order of child support. That order may be terminated upon the finalization of the adoption. However, I do want to note that that is not an automatic termination, so something to be aware of. If you have a client who has an existing order of child support, they must file for termination of that order of support in the family court before the support magistrate after the finalization of that adoption. The last bullet point here talks about a birth parent's right to seek visitation and custody of the child post-adoption. While it is true in this bullet point that it may be terminated upon the finalization of adoption, what we have now in our statutes are the post-adoption contact agreement that are currently only applicable for agency adoptions, but practically speaking, we have used them in private adoptions as well. So if all the parties consent before the judge to a post-adoption contact agreement, whether that's pictures, visitation, whatever that might look like for that family, if the judge signs off on it and all the parties agree to it, that can be enforceable at the present time under agency adoption, but also in some private adoptions in New York State. Next slide, please. So on our court's website, we do have a little bit more of when a person might be able to make that decision to choose to adopt. They discuss when a parent has died, which occurs, many times, and a relative will seek to adopt the child or a third party, or where a parent's rights have been terminated by the court pursuant to an order of child abuse and neglect. And the child is freed for adoption. There's many different scenarios. I like to call it the rainbow of adoption. So let's go to the next slide. Now here we're listing 4 categories of adoption, but again, I call it the rainbow because there are so many adoptions that one might be able to handle and file with the court. And that I like to think of them initially as 2 categories, right? We have private placement adoption and we have agency adoption. Within that private placement adoption umbrella, we have adult adoptions, which I have to note are one of my favorite adoptions to handle because they are just so special. You're usually dealing with a person over the age of 18 being adopted by their prospective adoptive parent, whether it's in a step-parent situation or just they established a true parent-child relationship. And that's the key phrase that I would like all of you to keep with you today, that for an adult adoption, they must show that they have a true parent-child relationship between them in order for that adoption to be finalized. Again, we have the agent. And so within that private adoption umbrella, you can also have what is bullet point 3 here, private placement adoptions from domestic or international adoption agencies. Those would come in as what we call them a readoption, depending on the type of visa that the child has been brought into the United States on. Or it could be a simple registration of foreign adoption documents because they've already obtained automatic citizenship by virtue of their adoption overseas. And they just would like to finalize and pursue a name change. It's a very simple proceeding with the court. That falls within that private adoption umbrella. Then other private adoptions would be step-parent or second-parent adoptions, which you would see with intimate partners. And then, of course, we have our infant independent adoptions of a child. Let's say the prospective adoptive parents have placed an ad in actually online now is the more likely way of them placing their ads or in a paper. And they've connected with a birth parent and then proceed through a private placement adoption that way. And as I mentioned, we also have the agency adoptions, which can occur through foster care, through the Department of Social Services outside of New York City or ACS within New York City, or a private voluntary placement to a foster care agency that is authorized through the Office of Children and Family Services in New York State. Next slide.
Hi, Maria. If you
Yes.
can maybe answer this question, or
Sure.
if you want to reserve it until the end, there is a question that we received in the chat. It says, does an adoption render the child ineligible for SIJ or special immigrant juvenile status
Absolutely.
based on biological parent abandonment, neglect, abuse, or death as a similar basis under the New York law.
No, absolutely. Actually, in fact, I believe there is case law that indicates that as a result of an adoption, a person can still pursue a SIJ for a child. Absolutely. And in fact, Judge Davidson at the time did have some of those cases where an adoption occurred and they applied for SIJ for the child. Okay, so now let's talk about, and it's very important to look at where do we begin with this, applicable adoption statutes. First and foremost, you're going to go straight to the Domestic Relations Law, DRL Article 7. That's going to cover adoptions, both private placement and agency, from adoptions generally through the effect of adoption for a child. Next, we want to take a look at the New York State Uniform Rules for the Family Court. And Kelsey's going to be talking about our checklist later on. But in addition to those checklists that you're going to get from the whatever county in which you file, you want to take a look at the Uniform Court Rules, because most of what's on the checklist is going to be coming from our court rules and the statutes, of course. So Part 205 is the section that you're going to look at in 22 NYCRR. And that's going to cover the timing and venue of filing of adoption petition, the papers that are required, investigation by a disinterested person, and in addition, special applications to be made to the court for both private and agency adoptions. Part 421, I believe, is a typo, so we're just going to disregard that, but certainly you want to definitely hone in on these first two statutes. And of course, cannot forget that social services law. That covers mostly agency adoptions, and 372 is a portion of it, but you're going to want to look at 383, 384. They cover agency adoptions, but also sections with regard to surrenders, extrajudicial surrenders to an agency, and requirements that are involved in those areas, and also placement through the agency. Next slide. So when you take on adoption, it's very important to think about proper adoption terminology. And I brought this slide for a very specific reason, because as lawyers, we know that words matter, right? So even changing something as simple as a woman gave up her child to she made a plan for her child makes a difference for the child and for the family and for everyone involved. It drastically changes the idea and foundation of open adoption. And it can be painful to a mother to hear that she is not, for example, the real parent versus a birth parent. So using birth parent and saying she made a plan gives acknowledgement to the decision that she made. I've listed a few: affirming adoptive language, as I said, birth parent versus real parent, making an adoption plan versus giving up a child, two parent versus to keep. There's so many here that you should pay attention to and hopefully in your practice use when handling adoption with your clients and with the court and all parties involved. Next slide. So who can adopt? We again go to our statute to discuss who can adopt. And in New York State, an adoptive parent must be over the age of 18 years old. It also lists within that section specifically that an adoption can take place by an unmarried person. So a single person may adopt alone. A married couple must adopt together. Two unmarried intimate partners may adopt together. And a lot of these changes within the statute, because this wasn't always reading the way it does today, comes from some big case law as far as changes to same-sex couples adopting together, and going back to Supreme Court decision there, so that now the way they file together as intimate partners or married couple is different. Also, we look at a married person who is legally separated may also adopt. That would also determine whether they're living, whether or not the court would require, let's say, a married person living separate and apart would determine if they are legally separated or living separate and apart from their spouse for 3 years or more. They can adopt. Also, an adult minor couple adopting a child born to either of them in or out of wedlock may adopt, or an adult minor couple adopting the child of either spouse. So those are the categories of who can adopt at the moment in New York State. Ever changing. Next slide, please. So I think this is you, Karla.
Okay, thank you so much, Maria.
Thank you.
Definitely, Maria, Kelsey, if you see any questions pop up in the Q&A, please feel free to jump in. This is going to be a Herculean effort to get through the first point. So, you know, there is a wealth of information that we're sharing, even for focusing on private adoptions that are not through an agency or through out of foster care. So, you know, bear with us, but also I think the greatest point that we can make is you want to definitely lean heavily on the law, lean heavily on updates on the court's website, as well as checking in with any adoption unit or part clerk for the county in which you might be filing. And it's also advisable, if you are not yet sage and an expert in this area of law, to reach out to other attorneys who may be able to advise or give guidance. But I want to start off with just really quickly, we're going to focus primarily on point 1, which are the 2 legal standards for an adoption. One is essentially standing. Does the adoptive parent have the grounds? And in this case, adoptive parent, much like kind of the affirming language that Maria spoke to, unfortunately, the statute is written as is and may use language such as father or mother. And again, we haven't caught up to have that language be reflective of where we are today. So just highlighting that. And in this case, the adoptive parent would be the petitioner in this case. And for example, if this was a step-parent adoption, it's just the adoptive parent, the step-parent, and not the biological parent, which could be the biological mother or father, again, just again, or initial parent, and there is a second parent adopting the child in the home or in the marriage. So one, does the adoptive parent or petitioner have the grounds or standing to even bring the case? We're going to focus mostly on that in this section. And then secondary, the court, not secondary in importance, but second to that, the court will turn to whether it's in the child's best interest to proceed with the adoption. Next slide. Okay, so we're going to focus on notice and consent in the context of legal grounds. Next slide. Okay, so really quickly, again, the rights of the biological parents, we're, as Maria pointed out, leaning heavily on DRL 111, or this is the relevant base in which we will be assessing whether there are grounds. And so DRL 111 describes when a parent's consent is required for an adoption, and it describes when a parent's consent can be waived. So we may not get into the thick of where there are opportunities to waive the consent. Again, looking to DRL, the domestic relations law will provide that guidance, and it will be referenced within the slides. And then DRL 111A pertains to fathers of children born out of wedlock. There has been some recent law in the area for agency or foster agency or foster adoptions for children out of foster care. As recent as December 30th, 2022, the governor signed the Parental Equity Act, which amends decades-old legislation, and there is an article in your materials as well. And again, this speaks specifically not to what we're covering today, so I don't want to focus too much on it, but it provides unwed fathers a full and fair opportunity to maintain custody of their child. There was a recent PLI in the annual children's law review that there is a section that goes over this in detail if you are considering taking on adoptions that have a foster care overlay and or potentially could be representing as a client someone who might benefit from this current law that's passed in December of 2022. Next slide. Okay, when is the parent's consent presumed to be required? So again, in general, the biological mother's consent is required in order for an adoption to proceed. The relevant point of DRL 111.1c, and in general, the biological father's consent is required. And if he was married to the biological mother at the time of the child's birth, a lot of this again is somewhat antiquated, but as the statute is today, where a child was born within a marriage, the biological father's consent would be required. Next slide. Okay, what if an adoptive parent, if you cannot obtain the adoptive parent's consent? So this falls into the area of abandonment, and the consent shall not be required of a parent or of any person having custody of the child where that individual, again, it doesn't have to be the father, it could be a person who would be required to give consent, including potentially the biological mother, where that individual has basically forgone or given up their right to care for the child, and that's been for a period of 6 months or longer, as well as visiting the child and communicating with the child or the person having legal custody of the child while having the ability to do so. Next slide. Okay, so we may not be able to get into the thick of the details, but this is all laid out in the slides. And again, you should turn to DRL 111 for any additional guidance that we're not able to cover in detailed ground today. But these are the three general categories of fathers, right? So there's a consent father where consent is required. In addition, the father would be entitled to notice. A notice father where consent is not required, but the father would be entitled to notice. And again, the rules are set out in DRL 111A. And then the third category is the putative father where consent's not required, nor is the putative father entitled to notice. Next slide. Okay, when is the consent of an unmarried father required? So DRL 111.1d provides that consent is required for an unmarried father of a child 6 months or older when the father has maintained substantial and continuous and repeated contact with that child. This means fair and reasonable child support is being provided, and one of these two other points, visiting with a child at least monthly, where physically and financially able to do so, and that the person having custody of the child is not preventing such contact, or there's regular communication with the child or the person caring for the child. And this is where they're physically or financially able to do so. Next slide. Okay, when is the consent of an unmarried father required? Continuing on to this point, an unmarried father's consent is an exception. His consent is required if he's been openly living with a child for a period of 6 months within the year immediately prior to proceeding with placement of the child, and who during such period has held himself out to be the father. However, the subjective intent of the father is not a reason to preclude determining that the father failed to maintain substantial and continuous or repeated contact. Again, we're looking at whether this contact has been maintained, or do we have a theory of abandonment for a father who would otherwise be entitled to consent. And again, we're not going to get into the exceptions, but you can look at DRL 111 1E. Next slide. Okay, and let's so incoming consent issues for child support. So this again speaks to whether the payments paid by a parent towards the support of the child are fair and reasonable, and according to the parents' means and ability to make such payments. This case essentially highlights that incarceration does not absolve a birth father of, within his means, providing financial support for a subject child or children. Next slide. Okay, who must consent for the adoption? Again, this is a 2010 case that highlights that an adoption requires termination of the rights of the biological parents. And so this invokes serious constitutional rights, as you well know, for biological parents. The purpose of these consents, the consent provisions, is to respect the constitutional rights of biological fathers, but only to the extent that the parent has actually attempted to assert parentage over the subject child. The unwed father his interests are protected and require both biological connection and full parental responsibility. Okay, this is distinct for unwed fathers who have had no chance to form a custodial relationship, however. Really quickly, the unwed father's protected interest requires both biological and full parental responsibility, biological connection and full responsibility. In this case, a child was placed for adoption where the father could have had more than a biological connection to the child. And however, there was no chance for a custodial relationship. The Constitution therefore protected the father's opportunity to develop a relationship with his infant daughter or son. However, this right only exists for unwed fathers who manifest his willingness to assume full custody of the child. So again, these cases are helpful in terms of making some distinctions. Next slide. Okay. Overcoming consent issues. Substantial communication on the point of DRL 111.6 highlights the ability to visit and communicate with a child or a person having custody of the child. Again, that contact, that communication may not be directly for that child, but as long as the parent is maintaining some communication. And again, the DRL 111.16 highlights the evidence of insubstantial or infrequent visits or communication shall not in and of itself be sufficient. So again, the court is going to weigh this in the totality of making a determination of whether consent is required. Next slide. And so we are also going to, in cases where it's warranted, determine whether the child's consent is required. So this is a threshold matter. This is a threshold matter of determining, again, not just purely looking at the age, and again, outside of consent of the child, the best interest. DRL 111.1a provides that consent is required of the adopted child over the age of 14 unless the judge or surrogate in his discretion dispenses with such consent. So again, in many cases, I'm sure presumably in all 5 counties within New York City, the court and the clerk is going to look for this consent to be completed for any child who's over the age of 14. Again, the court has discretion to determine whether it will be appropriate for the assignment of counsel. But again, the age in which we will use as the gauge for consent will be the age of 14. Next slide. Okay. So again, I told you it would be a whirlwind. So for sure, feel free to go back and look through the domestic relations pertinent sections regarding consent. And again, I think it's not as hard as it may seem in terms of assessing out which father, again, father you're using, or who may be potentially your client or the family you're working with, but it is imperative and important to sort of make that determination at the very outset. We are bumping up a little bit against time, so I'm going to just ask for the next slide. Okay, I think I may be able to go through this pretty quickly. Again, the pertinent section of DRL is 111A. So notice fathers are again entitled to notice, but their consent is not required. So who is a notice father? Next slide. Okay. Again, for the sake of time, I think I'm gonna move past this, but before we do, I just want to note that DRL 111A was enacted to protect limited constitutional rights of out-of-wedlock fathers who, under certain circumstances, receive notice of the proposed adoption, even though their consent is not required. So again, it seems complicated, but at the same time, while they're not required, their consent is not required to move forward the adoption, it is relevant for purposes of these fathers being identified as being properly notified of the proceeding before a determination is reached by the judge. Okay, next slide. Okay. And again, this is just giving some distinction between consent and notice father. But let's move on because I don't want to cut into the time for our third speaker. I think there may just be a few more slides. Next slide. Okay, so putative father really quickly, not due to notice or consent, right? So who is a putative father? A putative father is a man, in this case, who is not identified on the adopted child's birth certificate, nor did he sign an acknowledgement of paternity. Again, these are some indicators of who the individual who's held himself out to be the father may be. This is kind of a foot in the door, if you will. He is not mentioned, I'm sorry, in other cases, in the other prior cases of foot in the door. For him, there's no consent or notice required. He's not mentioned in a sworn affidavit written by the mother, was never adjudicated in court to be the father, was never named in a petition for child support. So often it is the case for many of our clients at MFJ where the father is not listed on the birth certificate. Father may have had very limited contact at the hospital, but then very much so was not in the life of the subject child. So that sort of father would fall into the putative father category. He's never come back into the child's life. He's never on his own gone to court to confirm that he is the father or filed a paternity case and is not contributing financially to the child's life. So essentially the putative father, as it would make sense, he's not really due that notice, and his consent is not required. Next slide. Okay, and again, this is some case law to support this. So again, I'm going to move past this slide if we can. And I think, yes, so this is just, again, just to note that the jurist or judge presiding over the case has judicial discretion in these cases, again, much like with the consent of the child, and waiving consent where it otherwise might be required in cases where there is effective abandonment on the part of one or both biological parents. The judge may supplement and ask for different information, including drug or alcohol screenings, facts or any history involving ACS, criminal history as well, proof of donor, essentially what may make sense in making this determination of what is in the best interest of the child. The judge is permitted to ask for different and to permit different records and information to come in. Essentially, strict construction is the general approach. And next slide. Okay. Next slide. Yes, so this, again, the focus for purposes of this webinar today is to focus on how do we get past barrier number one, standing. Best interest is considered in adoption cases, but I will leave you to the case law, but also to this slide for addressing if you are not working in adoptions or custody or guardianship or Article 10 or other matters in family court to better understand what this second hurdle, if you will, is for an adoption case. Again, I think the meat of where there could be additional hearings is with the first level of standing. And I think that is, if we could go to the next slide, I think this is where I may be turning things over to Kelsey.
Good afternoon, everybody. Much like my esteemed colleagues on this panel, I just wanted to say thank you so much for having me. Thank you to Mobilization for Justice and probono.net for having me today. I'm going to go through some of this a little bit quicker so that we can still have time for questions. So our first slide here is preparing the adoption filing. And so I do want to reiterate exactly what Maria said, to check out the rules and regulations of family court, to look at the law itself in order to use that as a template for filing your adoption petition. A lot of the documents that you will need are available on the court's website. That link is on this slide, right at the bottom right corner. And there are several documents that you need to fill out. There are checklists for each individual county. You can reach out to those different counties, to their specific adoption units and get them. They all generally have the same information, but sometimes there's specific things that different boroughs are requiring. I know there's a push, Maria has mentioned in our conversations, there's a push to get a uniform checklist out there to make everyone's lives just a little bit easier, but definitely use the different statutes and the court's website as a springing off point. I just wanted to highlight here, especially in a private adoption, this is the first time usually that a judge is seeing this family. So when you are putting together that adoption filing, that adoption petition, you're really presenting this family to the judge and saying, this is why we think that this is in the child's best interest for these individuals to adopt this child and bring them into their family. So in highlighting that, I want to say, the home study is really important. We definitely get home studies that focus a little bit more on the frills of a family as opposed to the meat and potatoes. The judge is reading this to say, is this child going to be safe in this home? Is this going to be a loving home for this child? So whatever social worker you're hiring, or if your client is indigent and needs the Department of Probation in New York City to do that, then that's definitely an option that is available, but you need to make sure that this person is getting into the meat and potatoes. What does the home look like? What is the interaction between the parents and the child? How is the child doing? The judges aren't looking for, the child was smiling and seems happy. What is the child's room look like? Are there toys? What's the specific interaction like? Please encourage your social workers to be specific when it comes to that. And certainly, any questions that you have, you can reach out to the different adoption units and the different counties. Again, the checklists are there for your help and your edification. Next slide, please. So this is some of the type of information that some of the documents that you're going to need to grab when you're putting together your filing, birth, death, marriage certificates. If any documents aren't in English, please get a certified translation. Here in the Bronx, we see a lot of documents translated from Spanish. We see a lot of birth and marriage certificates from specifically South American countries and Central American countries. The child abuse and neglect history, obviously this is important for the court to know whether or not this child is going to be safe in this home. It's usually filling out a request for the criminal history and the state central registry history to be run. And then the adoption unit, at least in the city, helps facilitate that getting done and that request being sent up to Albany. That is for anybody who's over 18 in the household. It's not just whatever, adoptive parent might be there. And just like Karla was saying, with the court having broad discretion, you'll sometimes see a court coming back and saying, hey, we want additional information on this adult who seems to frequent the home. So I've definitely seen that in my professional capacity as, say, a mother, a woman is seeking to adopt a child and her paramour is frequently in the home but hasn't quite isn't living there yet. But the partners have indicated that this is their plan for the future. So I've definitely seen judges say, I'd like the clearances run on the paramour since they seem to have very frequent contact with the child. You're going to have the health records of the adoptive parents, of the children, any medical history that might be known. Again, the home studies, which again, I'm please stressing to you to get the meat and potatoes of the home life so that the jurors can make an educated decision. Reference letters are always great to read. It's from members of the community, people who know the adoptive parents and who are suggesting that this person who has more day-to-day contact with the parent, the subject child, that this is a good relationship and that this is something that could go forward. That last line about double checking third-party submissions for legibility, signatures, and dates on adoptions, and I'm sure Maria, you would second this as well. A lot of times it's just the small things that fall through the cracks. The court attorneys are reviewing these. The way New York City works is they go through the adoption unit, then they get to the court attorneys and the judges are making a review. So it's going through a few different people. And a lot of times we're pushing back and saying, hey, you just missed a signature here, you missed a notarized a notary signature here. So a lot of times it's small stuff that holds up the adoption. So definitely just take your time as you're going through and make sure that you're dotting your I's and crossing your T's. Next slide, please. Okay, so the pre-certifications can be interesting. So it's basically the idea that before you're seeking to become an adoptive parent, you can go through this pre-certification process. I will say it's at the discretion of the court to waive this. You can either file a motion or the court can have its own, sua sponte, hey, we're going to waive the pre-certification. I would say check with the county that you're filing your adoption or would be seeking to file your pre-certification. And frankly, my judge often grants the motions to waive the pre-certs. Maria, I don't know if you see a lot more pre-certs upstate. I don't tend to see them around here.
We do, especially when they haven't yet identified a child to adopt. So when the prospective adoptive parents are seeking to adopt an infant and are placing their ad or seeking to place their ad online or in a paper, they go through the certification process so that they can be qualified in order to take custody of a child. But definitely in the step parent adoption area, or second parent adoption, as we like to call it, we have waived certification in those circumstances. Not all the time, sometimes we do require a certification depending on the circumstance, but we had a high number of certifications that were filed with us for sure in Westchester.
Great, thank you, Maria. So, definitely just double check with your client about what they are, looking to do. If it's, we're seeking to place an ad, you're going to definitely have to go through the pre-certification process. If it's more of a situation where they already have the child in their possession, through whatever steps were taken, and it's more likely that you're just going to be filing the adoption and requesting a motion to waive the pre-certification.
Just before you move forward, and this may lend itself to a prior slide or immediately prior slide or one before that's come up in the chat. One of the attendees asked, did you say that the court will facilitate obtaining a rap sheet or again, a criminal background history or certificate of disposition, or is that something that we should obtain before filing? And second question, do petitioners need to report a criminal record on the petition if the record has been expunged?
So I've seen that our adoption unit runs the rap sheets and has those documents they add into the adoption file. You just submit the request for that to be run, and it's again submitting the full name and the birthday of any adult over the age of 18 in the home. In terms of a criminal record that's been expunged, I think you're okay. You don't need to, because it's been expunged, it's been scrubbed from the record. I think pretty sure you're okay on that. But my suggestion too is be upfront on something. Don't wait for the court to find something, because that's a red flag when we run our state central registry checks or the criminal background checks and something pops up. Disclosure is always the better way to go. But again, with I think the expungement, that's a slightly different situation. Along those lines, really fast, I meant to mention this when I was talking about the home study. But when you get your home study back, before you submit it to the court, take a minute or two to read it and make sure that you think that your client's strengths and weaknesses are coming through. Like you read it and you say, okay, I feel like the court can make a determination based on that. And also make sure that it's consistent with the information that you're putting in your legal papers. I currently have an adoption that's on hold because the home study gives all this information about a gentleman who is the father of this child and the contact between the child and the biological father. And then all of the papers that I have from the lawyer indicate that there's no gentleman who is entitled to any sort of information. The mother doesn't even know who the father is. So clearly that was a big discrepancy, and that's something that you can flag at your level before you're even filing the adoption with the court. Next slide, please.
All right, there is another question that may be on par, Kelsey. I'm just going to read it. Does the adoption need to happen before the child's 18th birthday? I noticed the slide mentioned adult adoption. So I was also wondering if this was available for children between the age of 18 and 21 in New York.
I can answer that if you want. Let me just see. Does the adoption need to happen before the child's 18th birthday? That's up to you on how you want the adoption to look. Some people decide to wait till after 18. Adult adoptions are from 8. I think the oldest we had adopted was a woman who was 56 being adopted by her 95-year-old stepfather. So there's no age, end for an adult adoption, I want to say. I hope that answers your question.
I'll just add, I think for some of my clients, it's usually under the age of 18, but you creep close to 18 and it may just be the case that the attorney may not be able to file it in time, but often it may be to have everybody have the same last name, right? And maybe the adoptive parent is coming alongside the biological parent, a few years before the child is about to reach the age of 18, but also to it could be the case if there is an inheritance or possible inheritance that all the children in the home are able to take equally. So that may be something to also consider, and to at the outset ask what is the intention or purpose. A lot of times folks may confuse a name change, which is a separate civil process, with an adoption, and you can have the name change, but ultimately the point is really to say they're two different processes. And then Kelsey, I don't know if you see the fourth question, if you or Maria want to take that one, which is regarding criminal background check on adoptive parents. What about sealed records? That may be akin to expunged records, but I think ultimately, at least in my experience, we are often addressing any history, whether that's ACS or criminal history. It could be mild or minor. It could be domestic violence related, or it could be an order of protection, something along those lines. Again, I think maybe Kelsey, if you want to take this, but I think better safe than sorry, and to sort of address it, even if you are to then say, and that was the only point of contact that I had with the law. And, I've been, working and living with my family with no issues or incidents since.
I would agree and say that better safe than sorry. As Kelsey mentioned, the worst scenario would be that you don't disclose, and then the court is going to question why you didn't and bring it in for a character hearing, which is what we would frequently do in Westchester. If there were a rap sheet that popped up and someone didn't mention it within their petition, bring the parties in, do a quick character hearing to ensure that it is in the child's best interest to proceed with the adoption.
I think we can go to the next slide. So this is more about the pre-certification. Again, I would, in the interest of time, I'm not going to read the slide to you all, but I highly encourage everyone to do a deep dive into the law and the statute themselves. Again, they're written there and they guide our practice, so definitely use that to assist you in the filing of your adoption. And then just as it's flagged, there are certain convictions that would disqualify you from becoming an adoptive parent. Next slide, please. So just kind of a wrap up, certain things to make sure that you are doing when you're communicating with the adoption unit. And then I think, again, like you are all quite able to read the slide. I don't want to spend the time reading it to you, so that we do have a few more minutes for questions. But we can go to the next slide. Okay, so typically this is a date that's set by a tentative date that's set by the adoption unit. At least the way it's been working here in the Bronx is the adoption unit reviews the file. They say, hey, these are the things that we think you need to fix, or we think that this file looks good to go, and we're passing it on to the court attorney for review. And you'll get a tentative date for a potential adoption. This is also touching on notice, if there does have to be notice to any biological parents. This is kind of going into what Karla was discussing in terms of notice and consent fathers, which again, we're not going to get into quite today, but definitely spend some time familiarizing yourself with that. That law did change recently, as Karla was mentioning. If biological parents have already consented, like there's surrenders, signed surrenders in the paperwork, and sometimes that'll also include the post-adoption contact that Maria was talking about, then you might not need these dates, and then it's just a date for the tentative adoption. And then personal service would be required unless it's waived by the court. Next slide. Again, due diligence. I've seen, you know, parents served via social media. That's a new way to find an absent parent. So you would just make a motion for substituted service after any sort of attempts to find an individual in personal service have failed. Service by publication is always, you know, a last resort. That's the way you would attempt to do notice for any parent that would need to be notified of the adoption. Next slide. If there's service, the person doesn't appear, then, you know, the court essentially does this on default. It's very quick. Basically, you come forward and you would say, you know, this person may have been entitled to, you know, notice your consent. They're not here. They've defaulted. We're asking the court to move forward with the adoption. If the parent does appear, everything's going to likely be paused for an attorney to have it be assigned to speak to that parent and determine, you know, how they want to proceed. And again, the slide lays out the potential steps for that. Next slide. Okay, this is the best part. This is the adoption, the finalization hearing. So often the way it works in the Bronx is I get to send my favorite email that says, congratulations, the adoption has been approved. It's been scheduled for X date at Y time. Here right now, adoptions are virtual in Bronx Family Court. So here is the link. Please make sure that your clients are appearing via video. Please have them test out the link before the adoption. If there is any need for an interpreter, please let us know so that we can have them so that we can move forward. And the judges usually tend to ask like a few questions after the adoption. You know, do you have any plans for today? It's always really cute seeing the celebrations that families are putting together for the adoption. It's moving then into frequently asked questions. Just really quick, answering these questions. How long does it take to complete an adoption? It completely depends. It depends on how complete your petition is when you file it. Again, if you dot your I's and cross your T's, it's probably going to go a lot faster. Will you be eligible for an adoption subsidy? Not if you're doing a private adoption. If you're doing the foster care ones, that's a different situation and you would be entitled to the adoption subsidy. Impact your public assistance. Once you have, you know, the adopted child, you can add them to your public assistance. Finding a social worker. I actually don't know the answer to that question. I don't know, Maria, Karla.
Yeah, I was going to say, I think reach out to the county, and if it's within the 5 boroughs, if the county you would file in doesn't have the list, which I think is like from 2015, but it is a pretty long list of folks. And I've also filed a case in Bronx Family Court for a family where they had already worked with a social worker. Essentially the mother, the bio mother, again, the families come in different flavors, but basically the adoptive mother, the bio mother essentially was the adoptive mother. She adopted her daughters, and then her husband, who she married, the adoption was for him to adopt her daughters. So she'd already worked with a social worker when she adopted her daughters, and essentially she was awesome. I don't know what else to say. So you're not limited to just using whatever lists or resources that the family courts or your county may have, along the lines of making sure that they are licensed in the county, and then also that that they again, that they are regularly preparing home studies as opposed to just simply a social worker that you're working with.
And the statute, I just want to add that the statute does require that the home studies be completed by a licensed certified social worker or a licensed master of social work. So that is very important. And obviously probation as well is an option.
Yes. And then will the criminal history impact the adoption? It could. So again, this is where we're talking about, the disclosure is always the best way to do it. And then the court can hold the character hearing that Maria was discussing, sidestepping the disqualifying convictions. people make mistakes and the court is aware of that. So if you can come in and show them, if your client can come in and demonstrate that, you know, they've taken positive steps, and if that's something that has been left in the past, it's not necessarily going to lead to a disqualification.
I was going to say, when in doubt, again, if you are not the attorney, but sort of attending for purposes of referring or just, again, giving guidance, maybe your social worker, connect the would-be adoptive parent or parent to an attorney so that they can be advised, as opposed to assuming and then not moving forward, with what could be obviously a happy ending for the family, resulting in an adoption. So get the advice of an attorney.
And I think that's it for me.
And so we are right at 2. I would just advise maybe if folks with probono.net can just keep things open for a minute. If folks do have questions, if attendees do have questions, you can still go ahead and enter those. And thank you for submitting questions. These are really excellent questions into the Q&A. And if we are able to answer those questions fully, we will reach out. I think we'll be able to be responsive to those folks who drop questions in the chat. So I don't know if we can keep it open for a minute or 2. If not, our bios are in the materials, and you're more than, I think, welcome to reach out. I will say for myself, if there are any questions, or to folks with pro bono, and they'll funnel those questions along to us. But thank you all for joining. I'm gonna hand it over to Jeannie.
Great. Well, thank you all. And thank you to our participants for joining. We'll share the information, follow-up training information via email, and hope you enjoy the rest of your day. Thank you. Take care.